Hello students and welcome to the lecture. So students, as we know that we had started the discussion over the topic of the fundamental rights in the previous lecture. Okay. And basically we had discussed the topics like the meaning of political freedom. Okay. Like what is the social freedom and what is the economic freedom, right? That is what we had discussed in the previous lecture. Okay. Even what we have discussed, that we had discussed freedom, political freedom has been provided by the fundamental rights, while the other two types of freedoms are basically provided by the directive principles of state policy, right? That is what we had discussed. Okay. And as we know that the fundamental rights are basically provided, or you can say brought from the United States of America. Okay. That is we had discussed. And the directive principles of the state policy are basically brought out from the Constitution of Ireland. Okay, this is the thing. Even what we had discussed, if we talk about the fundamental rights, so they are provided in the Constitution, part 3rd of it, and basically there are articles from articles 12 to 35. Okay, so that's the picture what we have created all together. All right. So basically in this lecture, we are going to start from where we had left in the previous lecture. Okay. So this is the topic which we were discussing in the previous lecture. Like if we talk about the original form of constitution regarding fundamental rights. Constitution regarding fundamental rights. Original form of constitution regarding the fundamental rights. If we talk about it, then we had discussed that there are total 7 fundamental rights, right? In the constitution, which had been provided by the constitution. Okay. And these rights were like the right to equality contains the article 14 to 18. Right to freedom contains article 19 to 22. Right against exploitation contains article 23 to 24. Right to freedom of religion consists article 25 to 28. Cultural and educational rights article 29 to 30. Right to property article 31. And right to constitutional remedies article 32. Okay, that's what we had discussed. And even we had discussed that right to property article 31 has been removed later from the form of fundamental rights. Okay, and as I had promised you in the previous lecture, that basically in this lecture, when we will continue further in this topic, so we will discuss that right to property, why it was removed, what were the consequences of that time, and why it was happening. So let's begin. Okay. So this is the thing which I had told you, that however, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act of 1978. Okay. Now, many times I have seen people that who get confused between the 42nd Amendment Act of 1976 and the 44th Amendment Act of 1978. Like many times I have seen people who thought that the fundamental right to property from the fundamental rights had been removed by this one. But that is not true. Okay. Basically, it was removed by the 44th Amendment Act of 1978, not by the 42nd Amendment Act of 1976. Okay, and to avoid such kind of you can say the confusion, you are required to revise it again and again. Then only you will be able to grasp the fact and figure for a longer duration in your mind. Okay, thereafter it is made a legal right under article 300A part you can say 20th of the Constitution. Okay, sorry, part yeah, 20. Okay, so what we are seeing here. So basically, if we look at this, so we can say that the right to property was altogether not removed from the Constitution. Okay, it was only removed from the list of fundamental rights, and the fundamental rights are basically enforceable in courts. Okay, but later it was made as a legal right under Article 300A, this part of the Constitution. So it means that right now, if you go to the right to property, okay, then it is a legal right and basically not enforceable as per the magnitude of fundamental right. Okay, like we know, the fundamental rights are enforceable in the courts with a high magnitude, like writs jurisdiction. But when we go with the legal rights, so they are enforceable in the courts. Why? Because they are legal. But the magnitude of enforceability is lesser than in comparison with the fundamental rights. So at present there are 6 fundamental rights. Why? Because there were 7 and then the another one was removed. Okay. Thereafter, now we have to talk about the features of the fundamental rights. So the first thing which we could see here is the fundamental rights are basically guaranteed by the Constitution and also protected. Okay, guaranteed and protected by the Constitution. Okay, so now if we talk about the features of them, some of them are available only to the citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like the corporation or the companies. Okay, like we could say, if we talk about the fundamental articles, so they start from the article number 2, sorry, article number 12, and goes up to article 35, right? That is what we had seen in the starting of this particular series. Okay, so out of this, some articles are basically only available to the citizens. Like whosoever is the legal citizen of this country, that person only could avail the some of the rights, while the some other rights are universal in approach. Okay, and we could understand it like, if we talk about the fundamental rights, so basically we could divide it into the 2 forms. The first form is the exclusive approach. Another one is the universal approach. Okay, so if we talk about the exclusive approach, only available for citizens. Okay, these are only available for citizens. But when we talk about universal approach, available for all. So this is the division we could make under the fundamental rights as per the availability and the usage. Okay. Thereafter, they are not absolute but qualified. What does it mean? Absolute but not qualified. Okay. So as we had discussed that basically these are guaranteed and protected by the Constitution. It means that they must be, or you can say, basically, it means that provisions of them are to be implemented at all cost. That is the meaning of it. So this is what we call as an absolute. But this is half true. Okay. Like, however, they are guaranteed and protected. Okay. Okay. So, however, the provisions of them are to be implemented at all costs. So, this is the form of absolute. But when we take it to the broader picture and when we implement it to the people, then basically there are some restrictions applicable on the provisions of the fundamental rights. Okay, it means that the fundamental rights are not absolute. It means that if the provisions are given there in the fundamental rights, so there is no necessity that these will be implemented at all cost. Nothing like this. There may be some restrictions applicable on the provisions of the fundamental rights that make the fundamental rights qualified. It means that if the government feels that there are some conditions on which the restrictions is need to be provided on the provisions of the fundamental rights, the government could do it. But these restrictions must be for common interest, not for personal or political gains, and must not harm the basic structure of the constitution. Okay, like the restrictions the government could put on, but the restrictions are applicable for the common interest. The restrictions must not be used for the personal or the political gains and not be in a manner that they will harm the basic structure of the constitution. Okay, then only the restrictions could be put on. So that's why they are not absolute but qualified. Got it? The state can impose the reasonable restrictions on them if required. However, whether such restrictions are reasonable or not is to be decided by the court under the process of judicial review. Okay, thus they strike balance between the rights of individual and those of the society as a whole. Okay, that's why I had told you the restrictions must be for common interest, not for personal goals. Common interest, not for personal goals. Okay, between individual liberty and the social control. Thereafter, all of them are available against the arbitrary action of the state. So that's why in the previous lecture also, I had told you that these are for the political freedom, right? However, some of them are also available against the action of private individuals. Okay, like we could talk about it when we discuss the political freedom. Okay, so basically the political freedom signifies the government or state, right? But all the fundamental rights are not provided in the constitution for against the government or the state's arbitrary power, but also against some private individuals. It means that not only the government is required to work under the limited powers, but even the individuals like me and you and the private corporations, they are also required to work under some restrictions so that the well-being of the society or the individuals could be ensured. Got it? Thereafter, some of them are negative in character. Why? Because that is place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. Okay, like if we want to discuss it, I had told you that basically when we talk about the directive principles of the state policy, and then we will talk about the fundamental rights. So we had talked about it. The DPSPs are the positive in nature, and the fundamental rights are generally negative in nature. Okay, so most of you may be question like the fundamental rights are basically provided the protection, they are enforceable in nature. So why they are negative in nature? And when we talk about the DPSP, so it's good that they talk about the social and economical welfare, but we know that these are not enforceable in the courts. If someone is feels that his social and the social and economical freedom is hampered, even the person could not move to the courts. Why? Because the DPSP are not enforceable. So if they are not enforceable, why we talk about that? This is the positive nature. So basically, that is totally depend upon the government power to work upon. Like if we talk about the DPSP, provides provisions on which government could take actions and make policies. Okay. So this is basically giving the chance to the government to work. So that's why they are positive nature. While when we talk about the fundamental rights, so basically they provides provisions on which government power to take actions and make policies are restricted. It means that the fundamental rights are basically hampering the government's power. So that's why they are oftenly concluded as a negative. Okay. But some of them are also the positive. Why? Because they are giving the privileges to the person. Okay. Now let's move forward. So as we know that they are justicable. Why? Because they are enforceable. So if someone is, you can say, feeling that he or she's, sorry, his or hers fundamental rights have been deprived of, so they could move to the courts for their enforcement if and why they are violated. Okay. Second, they are defended and guaranteed by the Supreme Court. That's why Supreme Court is oftenly regarding as a guardian of fundamental rights. Like it is the responsibility of the Supreme Court to ensure that these rights must be defended and guaranteed to all the citizens living in this country. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the High Courts. Okay? They are not sacrosanct or permanent. What does it mean? It means that, as we had discussed in the earlier, that these are basically not absolute, but qualified. Okay. So basically they are not the permanent ones. The parliament can curtail or repeal them, but only by a constitutional amendment act, not by an ordinary act. Okay, and we know that when we talk about the constitutional amendment act, basically that comes under the article 368, and that's require the special majority, right? Okay, so it means that if the parliament basically wants that we should curtail or repeal some of the acts due to some reasons, so they could do it. But for this, they required the amendment under Article 368 that need to be passed by the special majority. Until or unless this not done, the parliament having no power to repeal or amend any act. Okay. Moreover, this can be done without affecting the basic structure of the constitution. Okay. So basically, if we talk about it, then we had discussed that under the provision of amendment of the constitution, as we had discussed. Amendment of the constitution, as we had discussed. So basically, what we had discussed, like the parliament can do the amendment if they want to. Okay. But the amendment powers are restricted when the question is changing the basic structure of the constitution. So whenever there is a matter of changing the basic structure of the constitution, then even through the amendments, the parliament could not affect the fundamental rights. Okay. Thereafter, this can be suspended during the operations of national emergency. Okay. Like whenever the article 352 is in the force. So the fundamental rights will be suspended except the two articles 20 and 21. Okay. And what are these articles? We will discuss in this lecture. Okay. Further, the six rights guaranteed by the Article 19 can be suspended only when emergency is declared on the grounds of war or external aggregation. Okay. And not on the grounds of armed rebellion. All right. The suspension of fundamental rights during a national emergency is explained in the chapter 16. Let's move forward. So their scope of operations is limited by the Article 31A, saving of laws providing for acquisition of estates, etc. Article 31B, validation of certain acts and regulations including in the 9th schedule, and 31C, savings of laws giving effect to the certain directive principle. So we could say that whatever laws and regulations passed by the legislation, whatever laws and regulations passed by the legislation, they all will be subject to the judicial review on grounds of fundamental rights, right? We all had discussed this thing, but there is a situation in it. Like if any law made under the provisions of Article 31A 31B, 31C. Okay, any law made under this 31A, 31B, 31C, then the particular law will not be, and you can say, put under the judicial review on grounds of the fundamental rights. Basically, it is an, you can say, exceptions to judicial review from point of view of fundamental rights. Got it? Thereafter, the application to the members of the armed forces, paramilitary forces, and the police forces, intelligence agencies, and analogous services can be restricted, okay, and abrogated by the parliament under Article 33. It means that when we talk about the individuals, when we talk about citizens or individuals, so basically parliament could not abrogate it or bridge away fundamental rights of them. Okay, like the parliament having no power to abrogate it or bridge away the fundamental rights of the normal people. But when we talk about the cases of armed forces, paramilitary forces, or police forces, or intelligence, or any state authority, okay, so remember, parliament under Article 33 having power to abrogate and bridge away their fundamental rights. So we could say, if we're talking about an individual and the individual is an ordinary citizen of this country, then his or her fundamental rights is to be implemented in a proper sense. But if the individual is a part of armed forces, paramilitary forces, police forces, intelligence agencies, or any other state authority, then the parliament is able under Article 33 to bridge away or abrogate or deprive of the fundamental rights of them. Okay, so that is the power granted to the parliament. Thereafter, their application can be restricted while martial law is in force in any area. Okay, like apart from the national emergency, if the martial law has been implemented in any area under Article 34, okay, then the fundamental rights will be suspended. Most of them are directly enforceable, self-executory, while few of them can be enforced on the basis of law made for giving effect to them. Okay, such a law can be made only by the parliament and not by the state legislature, so that uniformity throughout the country is maintained as per the Article 35 of the Indian Constitution. Okay, so students, basically in this lecture we have covered till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.